What's the difference between a Crown prosecutor and senior Crown prosecutor, the Ben Roberts-Smith case? Do you have any views as to how you think it's going to play out? How does somebody not know that they're a victim of domestic violence? Hello everyone and welcome to another episode of Sue Me Later. I'm joined today by Amy Pattle, lawyer out at ABA Lawyers, which is a law firm based out in North Lakes. Amy, welcome to the show. It's great to have you here.
Thank you very much for having me.
So let's jump into it. I want to get a bit of an understanding as to your legal career to date. I know we've got a bit of a switch, a little bit of a jump, which I think a lot of people find interesting because a lot of lawyers, they end up in one kind of specialization and they tend to stay there for numerous reasons. But you've made a bit of a jump from the criminal law side of things to family law. So let's hear a little bit about your background in criminal law and how that's transferred over to your family law practice area.
Certainly. Well, I started a very long time ago at the Office of the Director of Public Prosecutions as a law clerk and when I was studying law. So I did that for quite a number of years and then took a 12-month break to be an associate to a district court judge while I was doing my PLT accreditation. So that was a wonderful year and got lots of exposure to criminal court matters. And it sort of was how I fell in love with criminal law. And I stayed at the DPP for a long time. So I was an associate in 2014 and I've just switched into family law in 2026. So quite a long time with the director's office. During that time, I worked as a lawyer and then later as a Crown prosecutor and a senior Crown prosecutor. And so running jury trials and appearing at hearings as counsel in the higher courts. It was an exciting career. I loved it. I did jump into family law at the beginning of this year after 15 years with the director's office for a little bit of a change, but many people would think that it is quite different. There are a lot of synergies in between criminal law and family law, as I'm finding, and really it's people-centric, which is the sort of law that I'm very interested in. I think that anything to do with the drier sort of commercial law would certainly not be something that I'd be interested in. So I love the fact that I still get to engage with people on a day-to-day basis.
Yeah, I love that. Before we kind of get into the family law side of things, I wanted to break it down a little bit. So first question I had is, what's the difference between a Crown prosecutor and senior Crown prosecutor?
Really just the complexity of the matters that you deal with and that you look after. So you would still be running jury trials. As a Crown prosecutor, they're predominantly the trials in the district court. So you're looking at a lot of sex crimes would be the sort of trials you'd be doing as a Crown prosecutor. Senior Crown prosecutor, you do a little bit more in the Supreme Court or more complex district court trials.
And in terms of the height of the complexity, what are we talking about here? Are we dealing with murders, sexual type crimes in nature? What's the extent of things?
Yeah, as a senior Crown prosecutor, you wouldn't run a murder trial on your own. I did have the opportunity and was fortunate enough to junior our now director on a murder trial a few years ago, which was very fascinating. But as a senior Crown prosecutor, I ran sort of complex fraud trials. You would run drug trafficking trials in the Supreme Court. You would still run district court trials, so rape trials, more complex rape trials perhaps, trials with multiple complainants. You would also, you probably wouldn't run the shorter district court trials. So I'm talking about sort of one count of assault occasioning bodily harm, those sorts of things. So more complex and more involved matters because you have that sort of level of experience in running the smaller trials.
Okay, and help me out here because, I haven't done a lot of, I've only seen one jury trial in, my 13 years of being a lawyer. And that's just one I observed. I wasn't part of it. It's not something that is really common, having jury trials. So most of my understanding as to how they work and operate is from what other people have told me and also what I've seen on TV. So tell me something about during jury trials or running jury trials that you think people would find quite unusual or unexpected based on their preconceptions.
And I think, and I certainly would have spoken to quite a number of witnesses in trials that I've been involved in and told them it's nothing like television. So the first thing I think if you're ever a witness in a trial is that the lawyers do not come up to the witness box and shout in your face and slam things around. It's really not as dramatic as that, particularly for a Crown prosecutor because your job is to dispassionately and present all of the evidence. And it's not an episode of Ally McBeal, certainly. It's nothing like it. So I think a lot of people get really, really stressed that they're going to be attacked and that it's people shouting right in their face, and it's just not how it's run. It's quite sort of staid and quiet, and the barristers themselves are not allowed to move past the bar table, which is the table that they sit at. So that's probably a huge difference that people just aren't aware of.
And then how would running a jury trial, I guess, differ to running a trial without a jury? Do you think there are any key differences?
Oh, absolutely. I think when you're running a jury trial, you are conscious of the fact that you are speaking to a cross section of the community. So the 12 jurors that sit in a jury are not lawyers, they're not legally trained. So you need to communicate with them on a level that they would understand. If you're presenting a trial to a judge, I think the sort of language that you'd use, the emotion that you'd sort of try and convey in your submissions would be entirely different, because it's really then about getting the information to the judge as quickly as possible and being efficient, as opposed to communicating with persuasion to a jury. So I think it's completely separate audiences. And I think a good lawyer, a good trial lawyer, knows how to communicate with a cross section of audiences.
And around those trial juries, there's often this kind of debates, I think, in the media when it comes to these bigger cases, the ones that have got a lot of attention. And sometimes there's an issue as to whether or not it will run with a jury or not for various reasons. When it comes to that decision or making an application to have a jury or not have a jury, how does that whole process work? And who's more inclined to go for a jury? Is it more criminal defense, or would prosecutors think that they have better chances in front of a jury?
Look, to make an application to have a judge alone trial, is what they're called, you have to have proper grounds for it, and that's set out in the legislation. And it's something that actually we all got a lot of experience in during COVID because of the restrictions about having people come into the court. So we ran a lot of judge alone trials during that time period. Look, it's not frequent. It's not something that happens all the time, with the exception of that period, because the whole sort of fundamental basis of a jury trial is to be tried with a jury of your peers making the determination of fact. So there would be occasions, and there have been occasions, for example, when there's such a huge amount of publicity that follows a matter in the press, that it just would be unfair. You couldn't find a panel of 12 jurors where they hadn't been saturated by all of the media coverage. But in saying that, huge trials that have been through the media, like Brett Peter Cowan, who was convicted of killing Daniel Morcombe, had a jury. You can see that it's quite a rare thing for a judge alone trial to be granted, and there's a high standard that has to be met. In saying that, it could be an application from either party. I would say that it happens more from a defense perspective than it does from a Crown perspective, but it really depends on the individual circumstances of the case and the basis for it.
So there's one case that comes to mind that we could be potentially having that debate in. It's had a lot of controversy around it. It's the Ben Roberts-Smith case. Obviously, it's gotten a lot of attention. It's already had a trial before that's run in the civil courts in relation to defamation. And now it's gone through and there's been criminal charges. There's been a lot of talk as to whether or not it's going to be a trial by a jury, because there's been so much publicity about it already. I think there's a wide section of the general public that are already aware or have formed somewhat of a view as to what's happened in this case. Do you have any views as to how you think it's going to play out?
Look, I think with those sorts of cases, I mean, when a jury is sworn in, they swear an oath to judge the case by the evidence that's presented to them, and that alone. So yes, it's natural, I think, for people to have some background understanding, especially when a case has been presented in the media as much as that case has. But if a jury is, sworn in and swears that oath, I mean, I think the expectation is that most people would uphold that and base their judgment on what the evidence that's presented to them in the case and nothing else. And in fact, there's, I only have experience in the Queensland jurisdiction, but I'm sure the other states' jurisdictions have very similar provisions, that there's penalties to apply if jurors try and look for information outside of what's presented to them and then circulate that within the jury. And it can have consequences. It can cause a mistrial, and you can imagine the cost and the emotional toll involved in something like that. So jurors, before they start hearing evidence, are taken through that process, and they are presented to the court, and when they're sworn in, swear an oath or an affirmation that they would uphold their duties.
And have you had any issues with maybe a mistrial or jurors not upholding those duties?
Personally, no, I haven't as a Crown prosecutor. I have been aware of cases that have happened in recent times where jurors have, for example, posted on social media during a trial, and that has resulted in a mistrial, and that has resulted in potentially criminal charges being laid against that person. So it's very serious because it has such serious consequences for everyone involved. I mean, you can imagine being, for example, the victim of a rape, or you're in custody waiting for a trial, and you're, day 5 into your 6-day trial, and that happens, and you've got to start from scratch again. The emotional fallout from that, let alone the financial cost and the waste of the court's time, it's quite a serious thing.
For sure. I want to move over to something else. It's something that I've been seeing actually consistently every day in the news, and that's victims of domestic violence. And I think there's a strong kind of crossover between the areas of law that you have chosen to pursue, being both criminal and family law, where domestic violence is in, I guess, in that in-between zone. And what I've been seeing, I think I heard a stat that in the last week, there had been 4 women that had been killed by their partners across the country on consecutive days. And so, it's not something that is uncommon. We're hearing about it so much. Obviously, it's been brought to the attention of everyone in the last, I would say, 10 years. I would say before that, it wasn't so much in the limelight, but there's been a big push to kind of highlight this dark side, I guess, of the Australian community. And whilst we've got all of these increasing cases in the media limelight, we're dealing with on a daily basis these cases that have domestic violence. They're not in the media limelight, like they don't have any attention, but almost every inquiry that we're dealing with has an element of domestic violence of some sort. So that kind of crossover, I think, between the two worlds that you've practiced in, I think it would be invaluable. And I'm keen to kind of get your understanding, your insights around what you've seen when it comes to domestic violence. I think coercive control is also something that has been brought to light only in the last 2, 3 years. Before that, the term might have been used, but it wasn't a criminal offense. It wasn't something that was prosecuted. It wasn't something that was in the forefront of people's minds. But I think by legislating it, by making it a criminal offense, they're trying to almost create an awareness around it. That's I think what was my initial thoughts by making it an offense and kind of describing what the events are around it. So really trying to push it to the limelight and get it out there before we're dealing with these deaths that we're ultimately seeing on the ground on a daily basis, literally on a daily basis in Australia, which is, if you think about it, it's outrageous. So I'm keen to hear your perspective on domestic violence, on coercive control, on any cases that you've seen that kind of reflect that.
And I think coercive control, and the misconception really is, I mean, and we see in the media the cases that involve murders and deaths of women at the hands of their intimate partners. I think the importance, certainly, of the coercive control legislation is that it recognizes that domestic violence is not limited to physical abuse and physical assaults. And it's really, certainly in Queensland, was born the change, and the change in discussion was really born out of the murder of Hannah Clark and her children, which that case in the lead up to that horrific day, she was not the subject, as far as I'm aware, of actual physical assaults, but it was this sustained, prolonged abuse. Which led to, her murder at the hands of her ex partner. So I think that is certainly an attitude that really needs to be addressed more, and it's an attitude that I see now, certainly in crime and family law, where women predominantly, and I don't say that domestic violence is limited only to women being victims of it. Men are also victims of domestic violence, but predominantly we know from statistics it's women, where they are not sure whether or not they are the victims of domestic violence, or they stay in relationships for such a long time because their attitude is, well, he's not hitting me, it can't possibly be domestic violence. So I think the importance.
I'll stop you there, Amy, because that to me sounds wild. Like, how does somebody not know that they're a victim of domestic violence? Like, it seems a bit strange. It's like, if you don't know that you're, whether or not you're a victim of domestic violence, then surely doesn't it mean that you're not? Because
Absolutely,
doesn't
absolutely not.
domestic violence mean, that you're getting pain, or you're getting hurt or something? I think that's kind of the default position that people
Mm.
think of, right? So I just want to kind of explore that a little bit more, that concept of, hold on, is this domestic violence? Like, I'm not getting punched in the face here, but is there something more sinister in the undercurrent that I'm not aware of?
Absolutely, and that is really the misconception that the community at large has. From my experience with many, many victims of domestic violence can be financial control. It can be emotional abuse. It's being isolated from your family over a sustained period of time. And certainly the elements of the offence now of coercive control as a criminal offence are that it's a course of conduct that's committed over more than one occasion, and it's conduct that reasonably is likely to cause harm. So that is not limited to physical abuse. It's financial control, it's emotional abuse, it's emotional manipulation. It's all of those elements of control that are designed to manipulate and control. And I think it's really important that people understand that, because you have conversations with women who have been in these relationships for such a long time, and just over time chips away at their self confidence. And that really kind of is the vicious circle, because they become less confident, they become more isolated, they become more dependent. And it's all designed to have that end, that they are less likely to then leave that situation because of all of those things.
Have you got any examples of any cases where there's been situations where, yeah.
Yeah, absolutely. This is before coercive control became a criminal offence in and of itself. I remember one particular case that I worked on, and it was a sustained period of emotional manipulation. Physical control was an element of it, but not at the beginning. And I remember talking to the jury about and likening it to the old fable where if you put a frog into a pot of boiling water, of course it's going to jump out. But if you put the frog in the saucepan and then you very slowly over time just increase the heat, little increments at a time, the frog boils to death. I mean, and that is a very, very simplistic view of what coercive control is. But you're in the middle of the situation, and then the heat is just very slowly turned up over time until it's reaching that crescendo. And I think that that really is the complexity of coercive control, the conduct, the manipulation, that women are sort of not aware that they're in it until they're right in the thick of it.
It's a very powerful metaphor. I can see the impact of visualizing, that frog that slowly over time is cooking. I think it has a dramatic impact when you put it in that kind of light. So perfect analogy, I think, for this type of situation. So in terms of having that coercive control charge, what have we seen in terms of effect, actual charges being laid,
Mm.
coerce in for that, and how many people have been prosecuted, how many people have been convicted? And, you've given those examples, but I'm just thinking of from a police perspective. I'm thinking about it from a legal perspective. It would be hard to walk into a police station, for example, and go to a police officer and say, hi, my name's Hayder. I think I'm a victim of coercive control. The reason is I haven't spoken to my family in 3 years. I get an allowance of $100 a week from my partner. I feel like I'm cut off from everyone. I'm sad all the time. And if they're saying these things and they're going to talking to a police officer about it, I'm just wondering, the actual reaction to the police will give to this person, whether or not they're going to be able to substantiate some of these claims, whether they're going to pursue it in court. Because as you put it, a lot of these things are quite subtle. When the danger with those, I guess, subtle types of actions is they're hard to pinpoint, they're hard to get evidence around, and that makes it hard to prosecute. So whilst we've got all of these concepts in terms of what builds coercive control, what you need to establish a coercive control case, I'm just wondering, in terms of practicality of running it from a prosecution side, what are the challenges there, and is it feasible that they're going to be able to lay these charges and convict someone on this?
A recent article I saw was in the first 6 months of this legislation being rolled out in Queensland, 50 charges had been laid. So that's quite a number. I am aware that one person in Queensland has been convicted, and I think that was in August of last year, and received a 2-year imprisonment term. I know that another person was convicted in New South Wales of it as well. And I think New South Wales was the first state to have the coercive control criminal offence, and then Queensland followed. But in terms of proving it, I mean, the onus is always on the prosecution to prove the elements of the offence. And the elements of coercive control really are that it's a course of conduct, so it's got to be on more than one occasion. What that means, it's conduct that's intended to coerce or control. So it's showing that the pattern of behaviour is intended to control that person. So the example that you used, setting an allowance, a financial control. Over time, someone's not allowed to know what's in the bank accounts, and they're given X amount of dollars to survive on, and all of their pay is taken from them, or they're not allowed to work for it, as an example. Constant monitoring. Tell me where you are, check in with me, phone records that show constant communication throughout the day, monitoring someone's behavior, even people putting cameras in their house under the guise of security, but they're monitoring where their partner is. That sort of behavior would be a course of conduct. Conduct that is reasonably likely to cause harm, and it doesn't actually have to cause harm. It's reasonably likely to cause harm is one of the elements, and that's an objective test. So it's not subjective to the victim. It's that a reasonable person in that situation would find that conduct controlling and coercive. And the prosecution has to prove those elements beyond a reasonable doubt, but they don't necessarily have to prove that each intended act of violence that constitutes the course of conduct. So it's really looking for, to put that in very simple terms, a pattern. Patterns of financial control, patterns of manipulation. And I think one of the biggest changes of the piece of legislation that introduced coercive control as a criminal offence also changed preliminary complaint evidence, which is, in my view, huge. So, preliminary complaint evidence in a trial traditionally was for sexual offending only. And what it is, it's someone who had suffered some sort of sexual offence, who didn't report it to the police but told someone else. So, a person who told their mum what happened, or told their best friend what happened before they complained to the police. That conversation could be led as evidence, not as proof of what had happened, but to bolster the credibility of the complainant through consistency. So, someone who goes to the police 2 or 3 years after the fact, but the night after it happened, had this conversation, that evidence could be led at trial. That now can be done in domestic violence offending as well. So, and I think that that's really important, because we know that victims of domestic violence sometimes wait months, years to complain to the police, but on the way may have confided in people close to them at opportunities where they could. So that's a really important piece of evidence as well, because domestic violence, of course, most of it is behind closed doors. In our particular community, people aren't abusing their spouses in front of witnesses in the street. It's happening behind closed doors, and it's happening in that intimate relationship. So there's no objective proof with other witnesses who've seen things in a lot of cases. Sometimes there is, and sometimes children are exposed to it and they can give that evidence. But now we can leave that preliminary complaint evidence. I think that's a really important step forward.
Yeah, absolutely. Very, very interesting insights. And so, how does, I guess, that experience translate over to the family law matters that you're dealing with now? Like, what have you seen in the family law matters that you're assisting people with? And how do you think, I guess, that analytical kind of process now translates over?
I think, I mean, family law, domestic violence is, of course, part of it. And even in things like property settlements, domestic violence is a relevant factor. And I think it's so frequent. It's conversations that I'm having almost daily with clients. And I think a from that sort of coercive control background, a lot of these people are not aware, or don't understand the severity of what's happened to them, and they sort of brush it off. And it might just come up in a side point of a conversation. And when you delve into that more deeply, uncover that actually as people have been the victims of domestic violence. So it's, I would say, completely um, common in family law to be engaging with people who are victims of domestic violence. And I think the training that I've had and the wonderful training that I've had from the director's office really enables me to communicate, I think, quite effectively with victims of domestic violence and talk them through if they wanted to pursue, for example, a protection order, what that involves, what questions they'd be asked, what sort of evidence we'd need to lead, what cross examination would feel like, and what they could expect to be asked about. The different sorts of evidence that we could start gathering for disclosure material, just those preliminary conversations. And I think that is so important because it is such a big decision to pursue. And it's not, if you don't want to pursue it, that's completely a choice for you, because there is going to be questions asked. You are going to have to answer questions about, what's happened in the past, why you didn't report it, all of those sort of questions and really assertions that you have let this go on for so long. And I think that really scares a lot of people. And walking them through the process, giving them all of the information so that they can make the most informed decision, I think is the best way to approach it, because it's ultimately that person's decision.
Yeah, you mentioned something that really stood out to me, and that was sometimes they'll give you a piece of information, and with that information, you'll start digging. Can you give us an example of what you mean by that?
Yes, look, the most obvious is I will, especially if we're going through a property settlement, I'll start asking questions about an asset pool. And if someone can't tell me what's in their asset pool, it is immediately a red flag to me that perhaps they are someone who is suffering some sort of financial control. They
Hmm.
don't have access to their bank account. They don't know, or they weren't aware that their mortgage had been refinanced from their partner. And now that they're in that asset pool is debt that they had no awareness of. There's money that's come in, they don't know where it's gone. So that is sort of an initial trigger for me. If someone doesn't know about their own finances, it's something that would prompt me to ask further questions about that.
That's a good tip, and I think a lot of people could benefit from that kind of strategy when they're talking to their partners, or when they're having these discussions. Because yeah, I guess a lot of the time, if they're left in the dark, they might be in the dark for a reason.
Mm.
And they might not want to think too much about it and might think, yep, it's all okay. But there might be something under the surface as a result of that. And like you said, could be because they're taking out more money from the mortgage, could be because they're taking out loans. Maybe there's something that they don't want you to know. And that's why you are in the dark.
And I think also when you become aware that a client is a victim of domestic violence, giving them the agency and the autonomy to make the decisions and how you frame that. I mean, a lot of these people, women and men, but mostly women, have had all of the control taken away from them for quite a long time. So speaking to them in terms of giving them that power back, I think even just something that small can mean a lot, and it can start creating a bond of trust between the two of you. I mean, of course, lawyers operate on instructions, but understanding if a client who is getting out of a domestic violence situation does not want communication to the other side to be as adversarial as you would like it to be, understanding the reason for that, and and supporting the client in their choice without judgment.
I think that's a somewhat positive note to end on. Getting an understanding and I guess empowering victims of domestic violence, not just treating them as, I guess, a continuation of the control, but giving them the power, making them make the decisions themselves, giving them the right information so that they can break that cycle in a way where they're, not constantly feeling like they're being controlled by things outside of their own free will. So I think that's very empowering. I think it's a positive note to kind of break that cycle. So Amy, it's been great to have you on the show. You've shared a lot of insight with us, and I'm really excited to have you back. I think you're doing amazing work with the team at ABA, with your family law matters, and with your previous experience. I think it just really is a huge value add to the clients, because they're coming in expecting one thing, but you're providing a whole different perspective. So well done, and keep it up. And thanks for having a chat with us.
Thank you so much. Thank you for having me.